Good morning, students. The topic of our lecture is Supreme Court of India, its powers and functions. The topics covered in this lecture are Constitution of Supreme Court, Supreme Court as guardian of Constitution, writ jurisdiction of Supreme Court, jurisdictions of Supreme Court including original jurisdiction, appellate jurisdiction, etc. Supreme Court as a court of record, and power of Supreme Court to do complete justice. Supreme Court of India has been envisaged by the constitutional makers as the guardians of the rights of the people. So the right of constitutional remedies by approaching the Supreme Court of India has been guaranteed under Article 32 of the Constitution of India. Five kinds of writs can be issued for the protection of rights of the people by the apex court. These rights are writ of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. These are known as prerogative writs. Apart from issuing these writs, Supreme Court has been given the power to give any direction for the protection of the fundamental rights of the people. Article 32 has been described as the heart and soul of the Constitution, because vesting of the fundamental rights is of little significance unless a remedy for the enforcement of those rights has been provided for in the Constitution. Constituted under Article 124 of the Constitution of India. This article lays down the procedure for appointment of judges. It provides for qualification of judges and the procedure for the removal of a judge. Article 124 provides that the Supreme Court of India shall consist of Chief Justice of India and such other number of the judges as Parliament may by law provide for. Presently, Parliament has provided that there shall be 30 judges apart from the Chief Justice of India who shall constitute the Supreme Court of India. Article 124 clause 2 provides for the mode of appointment of a judge. It provides that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such number of judges of the Supreme Court and the High Court in the states as the President may deem necessary for the purposes, and shall hold office until he attains the age of 65 years, provided that in the case of appointment of a judge other than the Chief Justice of India shall always be consulted. Article 124 clause 3 of the Constitution provides qualification of a judge. It lays down that a person shall not be qualified for appointment as a judge of the Supreme Court unless he is a citizen of India and has been at least 5 years a judge of the High Court or 2 or more such courts in succession, or he has been for at least 10 years an advocate of the High Court or 2 or more of such courts in succession, or in the opinion of the President is a distinguished jurist. The process of removal of the judge has been provided for in Article 124 clause 4 of the Constitution of India. It says that a judge of a Supreme Court shall not be removed from his office except by an order of the President passed after address by each House of the Parliament, supported by a majority of the total membership of the House and by a majority of not less than 2/3 of the members of that House present and voting. Article 124 Clause 5 provides that Parliament may by law regulate the procedure of the presentation of address and the investigation and proof of the misbehavior of incapacity of a judge under Clause 4. The process of removal of a judge is known as impeachment. Only Parliament, by following the procedure under 124 Clause 4, can remove a judge, or in other words, can impeach the judge. The difficult procedure for removal of a judge or impeachment has been laid down in order to ensure independence of the judiciary and to ensure that judges give their decision without any fear or favor to any party. Article 128 of the Constitution of India declares that Supreme Court shall be a court of record. A court of record has certain inherent powers. The evidentiary powers of the records of records. The records of a court of record, which the Supreme Court is by virtue of Article 128, cannot be questioned in any court of law. They are an evidence in themselves. A court of record is the court which has the inherent power to punish for contempt. It means that it does not require any statutory backing to punish for the contempt of itself or for the contempt of the lower courts. It has the power to administer justice according to the law in a regular, orderly, and effective manner. Further, Supreme Court, being a court of record, is empowered to uphold the majesty of law and prevent interference in the due administration of justice. Thus, the Supreme Court, being the apex court of the country, can take any action which is considered that these actions may have repercussions in the due administration of justice by the court. India, being a union of states, it is likely that there may be disputes between the union and different states or between the states inter se. So, original jurisdiction of the Supreme Court of India deals with the resolution of such disputes. A private individual under Article 133 cannot bring a suit directly to the Supreme Court of India. Such suits may be brought either by the central government or by the state government. Under Article 131, Apex Court has jurisdiction over the suits between the Government of India and between one or more states, between the Government of India and one state on one hand, and one or more states on the other hand, or the suits between two or more states can also be subject matter of Article 131 of the Constitution of India. Is the highest court of appeal in the country. It is known as the apex court. The writs and degrees of the court run throughout the country. The jurisdiction and power exercised by the Supreme Court are wider than the highest court of any country, including United States of America and England. The appellate jurisdiction of Supreme Court can be divided into following categories: constitutional matters, civil matters, criminal matters, and special leave to appeal. As regard the power of Supreme Court in constitutional matters is concerned, it has been provided for in Article 132, Clause 1 of the Constitution. It provides that an appeal shall lie to the Supreme Court from any order, judgment, decree, or final order of the High Court in civil, criminal, or other proceedings, provided the High Court certifies that any question related to interpretation of Constitution is or any substantial question of law is involved. Where such a certificate is given to any party in case such appeal in the Supreme Court on the ground that any such question as aforesaid has been wrongly decided. Article 133 provides that an appeal shall lie to the Supreme Court from any judgment, decree, or final order in civil proceedings of a High Court only if the High Court certifies under Article 134A that the case involves a substantial question of law of general importance, that in the opinion of the High Court, the said questions needs to be decided by the Supreme Court. Article 134 of the Constitution deals with the appellate jurisdiction in criminal matters. According to Article 134, an appeal shall lie to the Supreme Court from any judgment, final order, sentence in a criminal proceedings of a High Court in following two ways. Number one, without the certificate of the High Court, and number two, with the certificate of the High Court. An appeal shall lie to the Supreme Court without the certificate from a High Court if the High Court has on appeal reversed an order of the acquittal of an accused person and sentenced him to death, has withdrawn from trial before itself any case from any court subordinate to its authority, and has, in such trial, convicted the accused person and sentenced him to death. But if the High Court has reversed the order of the conviction and has ordered the acquittal of an accused, no appeal shall lie to the Supreme Court. The with appeal may lie to the Supreme Court with a certificate of the High Court. Under Clause C, an appeal shall lie to the Supreme Court if the High Court certifies that Article 134 Clause A that it is fit case of appeal to the Supreme Court. The Supreme Court may grant special leave to appeal against any order etc. of any court of the country, not necessarily from the High Court, in which conditions we shall find out in the course of our discussion. Constitution gives the right to hear special leave to the Supreme Court from any order or determination etc. from any court within the territory of India. Article 136 Clause 2, however, excludes from the purview of the Supreme Court any judgment, determination, sentence, or order passed or made by any court or tribunal constituted by or under any law related to the armed forces. The scope of Article 136 Clause 1 is therefore very wide and comprehensive, and it invests the Supreme Court with a plenary jurisdiction to hear appeals. Its broad and overriding nature is evident from the following features. Under it, in the suitable cases, Supreme Court can hear and even disregard the legislations contained in Article 132 to 134 in its appellate jurisdiction and hear appeal which it could not otherwise hear under these articles. Articles 132 to 134 deal with the right of appeal against the final decision of the High Court. Article 136(1), on the other hand, uses the word any court and thus empowers the Supreme Court to grant special leave to appeal from judgments not only of the high courts but also from the lower courts in India, even without having the recourse to the usual procedure of filing an appeal in the High Court. Some significant powers are conferred upon the Supreme Court under Article 141 and 142 of the Constitution of India. Article 141 says that decisions of the Supreme Court shall be binding on all the lower judiciary in India. It means that decisions of the Supreme Court are precedents. However, it has been laid down that only ratio of the judgment is precedent and not the obiter dicta, that is an observation which has no direct connection with the facts of the case. Article 142 confers the power upon the Supreme Court to pass any order which it thinks that is necessary to pass in order to do complete justice between the parties. It further provides that the any order thus passed by the Supreme Court will be enforced and decree or order passed by the Supreme Court will be enforced upon any court or tribunal of the country. Article 143 of the Constitution of India vests advisory jurisdiction on the Supreme Court. It says that when the President is of the opinion that there is a question of fact upon which it is necessary to obtain the opinion of the Supreme Court, in that case it can refer the matter to the Supreme Court of India. And the Supreme Court, if it thinks fit, can give its opinion on such a matter. In clause 1 of Article 143, it may be noted that the word may has been used. This word indicates that it is not obligatory on the Supreme Court to make a report on the reference made to it. In other words, the power of the Supreme Court to give it advice is discretionary in nature. Executive cannot force the Supreme Court to give its opinion on any matter. The court has discretion in the matter and may in proper case, for good reasons, it may decline to express any opinion on the question submitted to it. However, in clause 2, the word used is shall, which indicates that it is obligatory for the court to give its opinion on reference made thereunder. The experience of the few other countries may be useful and instructive in this respect. The US Supreme Court has consistently refused to pronounce the advisory opinion on abstract legal questions. Similarly, High Court of Australia has also refused to exercise advisory jurisdiction. In the light of this foreign experience, Supreme Court of India has considered the matter of its advisory jurisdiction in Re-Kerala Education Bill 1957, AIR 1958, Supreme Court 956. Following propositions may be culled out from the observations of the Supreme Court in this case. Number 1. The Supreme Court may in proper case and for good reasons decline to express an opinion on a reference made to it under Article 143 Clause 1. The question of validity of a bill rather than statute in force may be referred to the court. For Article 143 Clause 1 does not contemplate reference to a question of law that is likely to arise. It has been further observed by the apex court in this case that it is for President to determine what questions should be referred to the court. The court cannot go beyond the reference. The reference material for further studies by the student include the book of MP Singh on the Constitution, that is V.N. Sukla's Constitutional Law of India, published by Eastern Book Company. Along with this, the student is also required to take help from the Constitution of India Bare Act. The case is referred as SP Gupta versus Union of India, Air 1982 SC 149, which is also known as the Judges Transfer Case, and explains the collegian system that exists in India. In this slide, you can see the questions which arise from our discussion of the topic, that is Supreme Court of India, its powers and functions.